Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This is also Jurisprudence. So we are completing the question paper of 2017. So please refer to question number 18 of 2017. Part C, you may be knowing. So the brief facts are, some women employees, they are working in industry. Right? What is industry? If you go to section 2G of the Industrial Disputes Act 1947, you will be knowing. Some of them are breastfeeding mothers. That means they have recently given birth to their children. Of course, because of the poverty, they have to come to the factory and the work, and they have to take frequent steps or frequent slips for lactating the children. పిల్లలకు పాలు ఇవ్వడానికి. But the employer did not provide proper restrooms, and he also did not provide substitute relief. 2 points. The employer did not give them provide any restrooms. Even he did not provide substitute relief. So therefore, and he ordered them to work at odd hours and also at hazardous places. Very big. So now we have to discuss. So please remember, as regards jurisprudence, this is concerned as, so we treat our state as welfare state. It was converted from police state to welfare state. This is a sociological jurisprudence. Society, man is a societal animal. So welfare of the people is more important, right? Now come to the issue. Issue is whether the employer violated the conditions of providing proper restrooms, whether providing substitute relief, and also ordering them at working odd hours in hazardous places. The simple answer is no. Anyway, you have to give discussion, and then only you have to cite case laws, then only to conclude. Otherwise, you don't get any marks. Now come to the point of discussion. Right? Straight away, Section 47 of the Factories Act 1948. It gives a provision for shelter, rest and lunch rooms where more than 150 workers are working in a factory. So here some employees, industry and factory, both of them almost equivalent. Industry is an organization which provides services, goods or services. Here the manufacturing process is there in factories. Both of them are similar. Now, Section 47 says the employer should provide restrooms or shelter or lunch rooms if more than 150 workers are there. So here some women employees are working in industry. Let us assume that they are 150. So therefore, definitely they have to provide lunch room or restroom. So where case lies C.K. Choksi versus Commissioner of Income Tax 2001. Then second, Section 48. Section 48 says, since they have mentioned as breastfeeding mothers, I have involved this Section 48. Section 48 deals with the providing of Cresches, C-R-E-S-C-H-E. That means Uyala, Chanapallu Creche ante. So if more than 30 women are there in a factory or industry, definitely if there are breastfeeding mothers, they have to provide Cresches. ఈ పిల్లోడిని దాంట్లో పడుకోబెట్టి ఉయ్యాలు కుంట కసి వాడు నిద్రపోతాడు, then the mother will go and work there. So this is the purpose of creche. So Section 48 is also important. Since they are breastfeeding mothers, they can't leave the children alone. అక్కడ కింద పెడితే కీ అని ఏడుస్తూ ఉంటారు. అదే ఉయ్యాల్లో వేశారనుకోండి, వాడు కాసేపు నిద్రపోతాడు. So that is the advantage of providing sketch, so-called creche. In this case, please remember case law. State of Gujarat versus Sudhir Mehta. I'm sorry. State of Gujarat versus Sudhir Mehta, 1998. So no creches were found to the mothers, and actually this is Sudhir Mehta. This is relating to Milton factory. You all know Milton is very famous for preparing the so-called మన ప్రజలు టిఫిన్ చేసేది కానీ లేకపోతే చాలా క్యారేజెస్ అన్ని మిల్టన్ కంపెనీలో, ప్లాస్టిక్ కంపెనీ, వెరీ ఫేమస్ కంపెనీ. సో ది ఇన్స్పెక్టర్ వెంట్ దేర్ అండ్ ఫౌండ్ Cresches not available, therefore he filed a case against them on 21/9/95. Of course, so the court has agreed, and the court said, so since yours is a multinational company, better you provide them. Of course, they are given warning and let them off. Anyway, what you have to learn from section 48 is that the employer should provide Cresches. Okay. Now, coming to the Factories Act 1948, a person cannot work for more than 9 hours as per section 51 because this man asked them to work at odd hours. So no man or, for example, a person, let us better write a person. A person cannot work for more than 9 hours. Particularly, as per section 61 of the Factories Act, the woman should not be allowed to work between 7 p.m. and 7 a.m. Normally, 7 p.m. and 6 a.m. అంటే రాత్రి 7 గంటల నుంచి పొద్దున 6 గంటల దాకా women they should not be allowed to work. At the same time, definitely not between 10 p.m. and 5 a.m. 100%. ఇక పెడతాను లేదు. ఆడ్ అవర్స్లో నార్మల్లీ ఇన్ జనరల్ 7 p.m. నుంచి 6 a.m. దాకా. అదే ఒకసారి కొన్ని సంవత్సరాలు ఎక్స్ట్రా పైన అవసరం అయితే ఇట్ మే బి ఎక్స్టెండ్ అప్ టు 10 p.m. From 10 p.m. to 5 a.m. definitely no woman should be allowed to work in any factory. Right. And section 52, actually this is relating to, I can say, a little bit of substitute relief. So if there is a particularly woman, if she has to work for more than 9 hours and he has to give compensation, and if it is more than 9 hours, she may be allowed to do overtime. At the same time, she has to be given the so-called substitute relief. So this is important. So in this connection also another case law is there. This is KVV Sharma, manager versus unknown, 1952. The case that is INRI, we can say INRI KVV Sharma. So it's a very peculiar case because a petition from the workers, it has been taken as a case in 1952 itself by Madras court. So actually this case relates to Gemini Studios. Of course, presently you can't find that Gemini Studios is totally demolished, and if you go to Madras you will see the area called as Parson Maneri, and in that area previously the Gemini Studios, very famous SS Vasan, so that was there. Nowadays it is no more present. Same is the case with Vijaya Bahini Studios. Now they are totally become defunct. So here what happened is the cinema production at that time, 24 crafts, at that time different people were called to work during night time, night shift and other things, but they were not given any substitute relief and all these things. Therefore, some of them under the name of Akasha Ramanna, without signing they sent the petition and the court was pleased to take it on file. And there is a dispute. Gemini Vasan is not an ordinary man. Whether film industry is called an industry or not. So please remember whether Gemini Studio is a factory or not. So ultimately the court said it is not a factory because people coming and going, no regular work, only temporary people. It can't be called as a factory. Even though nowadays also people say that cinema industry, we cannot define cinema as an industry. So this is a fact. You have to agree it. But anyway, నార్మల్గా ప్రతివాడు ఇండస్ట్రీలో 24 క్రాష్ చేయాలి కానీ ఇండస్ట్రీ కింద ఎక్కడగా రిజిస్టర్ కాలేదు, మీరు చూసుకొని కావాలి. సరే, వాట్ ఎవర్ ఇట్ ఈస్, ఇట్స్ అ డిఫరెంట్ టాపిక్. ఇన్ దిస్ KVV Sharma, they said yes, the studio has to provide substitute relief in the time of night shifts, and women should not be allowed to work between 10 p.m. to 5 a.m. That is the finding in that case. And coming to the last point, that is hazardous process. So hazardous means where there is a danger to the life and liberty of every person. Life of every person, hazardous. Tanning factory, Shirkasi, match factories, so many things are there. Firecrackers manufacturing factory, industry, all these things are dangerous. This is called hazardous process. So no doubt, definitely hazardous process, some activity should be there. So the employer should accurately maintain health and medical records of all workers. And as per section 22 of the Factories Act, no woman shall be allowed to clean any part which would expose her to risk of injury, like cotton pressing machines, all these things. And another thing is maternity benefit act also says so nursing breaks should be given to the new mother for lactation of their children. So these are all beneficial acts. So the woman can claim benefits under the above acts, and the employer, if he did not provide them, he is liable for punishment. With this, I am concluding. Thank you very much.